Okay, this is the direct examination portion of this. Some of you were here last year. You've done this. You know this. This is fundamentals. Giving you a handout. The handout contains the Nevada Mock Trial Guidelines for Student Attorneys and Witnesses that kind of lay out for you with regard to direct examination what your objective is, what the purpose of it is, what you're trying to walk through. You've also got the competition rule, Rule 3, that talks about witnesses being bound by their statements, and we're going to go through that. And the unfair extrapolation rule, which is Rule 4, and we'll talk about that. And then Rule 42, which is the procedure for introducing exhibits. You will do that probably most often on direct examination. So that's why we're going to cover it here. So those are the rules, and then it is followed by the handouts from the PowerPoint. So if you've want to take notes, that's helpful. Your direct examination, as you've just learned from Mrs. McAllister, is going to be done in your presentation of your side of the case. So it's your version of the facts, what you want the court to hear, how you want the court to see and perceive this evidence. So let's talk about what is evidence. In your packet, you're going to have 3 witnesses assigned for your plaintiff, because this year it's a civil case, and 3 witnesses assigned for your defendant. As you read through those statements, there is information contained in those statements that is helpful to both sides of the case. So if you're the plaintiff, you're reading your witness statements to figure out what helps your side of the case. And you're going to pull that information out, and that's what you want the court to see. And you can kind of craft that in conjunction with your witness to be the story that you want to tell. You're going to pull out information that proves or disproves facts that are an issue in your case. Your evidence will include your witness's testimony and use of the exhibits that are in your packet. So there's verbal evidence, and then there's hard copy evidence. Who are witnesses that give testimony? As you look at your witnesses in the packet, you've got to ask some questions. Is this a person who participated in or saw the event so they can testify about what they saw or did? Is it a police officer maybe who responded to a crime scene? Or a person who created or drew a diagram or filled out a form, and they're going to testify about having filled out the form and what they put in it? Is it maybe an accident expert who comes in and reconstructs a series of events? Or maybe a medical expert who's examined someone that's a witness or a victim in the case that's going to give medical testimony about their physical or mental health or mental capacity? As you read through and ask those questions, there are 2 types of witnesses that you're going to present. One are lay witnesses, and Rule of Evidence 701 in your packet talks about lay witnesses. They are people that personally saw or heard something. They don't need specialized training or expertise. They don't need to have been trained up on how to read a medical report, any of that kind of thing. They're people who personally observed things. If we are in we see an auto accident as we're driving down the road and we pull over to give a statement to the police, we are a lay witness because we saw something happen. We're a witness to what we saw. We didn't have to be trained to see it, at least in theory we don't. And so we can testify about what we saw or heard. Expert witnesses. These are covered under Rule 702 to Rule 705 in your Rules of Evidence, and these are people who require expertise, specialized training and knowledge. Typically they're police officers or doctors. We've had some coroners that testify about cause of death, but they're a person you're going to put on the stand and they're going to tell your judge how much training and education they've had that makes them oh so special, so they can give you very specialized testimony. Witness information that you're going to provide through direct examination. What are your goals? Your goals are to convey the strength of your case. So you want this witness to tell your side of the story the way you want it told. You're going to have the witness tell the facts of your case the way you want the judges to hear them, in the best light possible for the side you're presenting. When you do direct examination, the focus is not on you as the lawyer. Lawyers, both in the real world and in mock trial world, tend to think the focus is on them, that the lawyers win or lose the cases. In mock trial world, that's not true. It's probably not true in real life either. But your witnesses, the scores on your witnesses are going to impact how your team performs as much as, if not more, than your lawyer scores will. We've won and lost rounds in this competition based on witnesses. So you need to think about, as you read through your witness statements, who on your team is going to portray that witness. Because in direct examination, the focus is on the witness. You as the lawyer are there to kind of open the door for your witness to talk, for your witness to emote, for your witness to convey the strength of your case and the conviction of what they saw and how they know they were right. It's not for the judges to focus on you. So your job is to open the door for them. When you craft your questions, as you go through the statement, you have to figure out what facts are relevant. You'll read through these witness statements, and there is a lot of information in there that doesn't have anything to do with your lawsuit. And I'll give you an example from a prior year. We had witness statements about kids who'd been at prom, and after prom they all went out for a boat ride. If there is testimony or information in your witness's affidavit that talks about the night before, we went out, we went shopping, she bought a red dress, I bought a blue dress, we were so excited, we looked so good. None of that information has any relevance to what they saw or didn't see with regard to the boats out on the lake after the prom. Now, it's interesting information. It provides some character maybe that you might want to develop for your witness, but it's not relevant facts. And you're time limited on how long your people can talk, partly because that's the rules, partly because you don't want to put anybody to sleep, so you got to focus on what you're trying to do. Okay? So you have to glean through your statements what's really relevant, what matters if you're trying to prove something did or did not happen in the dark on the lake at midnight that night. Maybe some of what happened at prom is relevant. Maybe somebody's been drinking at prom, and so that would impact their ability to perceive what they maybe did or didn't perceive on the lake that night. But what they were wearing and who looked better in their dress maybe isn't quite so relevant. And there will be lots of that kind of information in your statement. So part of your job, both as the witness and the lawyer, is to try and sift that out. Your next question is the witness competent to testify to what you want them to testify to? The easiest example of this is if your witness didn't actually end up out on the lake that night, but maybe they talked to people the next day about what they saw. Were they out there? Do they have any personal knowledge of what happened out there? Did they see it? Could they possibly have seen it? Were they standing on the shore? What's the basis for them coming into court and swearing that something happened? So you got to figure out what they know. If you have an expert, what's the basis of their knowledge? Do they have the appropriate training to give that information? If you've got, hypothetically, a coroner who's going to come in and give testimony about cause of death, you're going to have you'll have information in your packet that tells you what training that coroner had, what their background was, how long they've been a coroner, how many deceased bodies they've had to examine and determine cause of death. That doesn't give them any expertise to talk about how the boats collided necessarily on the lake, because he's not an accident reconstructionist, he's not an engineer. He can talk about what he observed in terms of wounds, but not about what happened on the lake, because he's not an accident reconstructionist. So you got to focus on what the qualifications are of your expert and focus his testimony on those qualifications. Your experts may opine about things in their affidavit that they don't really have the expertise to give expert knowledge about. So be cautious of that. Rule 401 is your relevance rule. So when your question is this information relevant? Rule 401 says information is relevant, although I've misspelled relevant. It makes a fact more or less probable, and the fact is of consequence. It matters in your case. How do you establish a witness's competence? You do that with foundational questions. Who, what, where, when, and how. They place the witness so that you know, so that the court knows why this witness is competent to testify to something. So, for example, if someone wants you to testify about coming to mock trial training on September 26th, or 27th, of 2014, you could be asked, where were you on the morning of September 27th, 2014? And you would say, I was at mock trial training. Where was the mock trial training? It was at Canyon Springs High School in their delightful courtroom classroom. Who was there with you? Well, and you can testify to all the people who came with you, your teacher coach, your lawyer coach, the other team members who are here. What happened while you were there? And then you can tell what happened at mock trial training and how entertained you were by all of this and how much you learned when you left, because you've established first that you were here, where it was, when it was, who was with you. So now we know you have a basis to talk about mock trial training because you've established that you were here. So those are foundational questions. They are also very open-ended questions. The lawyer doesn't supply the answer, the witness does. So that you're going to focus on that witness. Personal knowledge. It also establishes that you were here at mock trial training, so you can personally testify about what happened. Sample direct questions we walked through. What's your name? Where were you on the night of May 28th, 2013, or the morning of September 27th? Whatever your date is that matters in your case. Who was there with you? What happened? How long were you there? When did you leave? Where did you go when you left? You walk through the witnesses' stories with basic open-ended questions that allow your witness to talk. Expert witnesses. With an expert witness, before they start giving opinions, again, you have to lay foundation that they have a basis with which to provide that opinion. So you ask them questions that enable them to do that. Fundamental, what's their name? The judges are not going to know who your expert is versus the expert they heard in the round before. So your witness needs to tell the judges who they are so we know who we're talking about. What's your educational background? Where'd you go to school? What did you study? Did you get a degree? How many degrees do you have? Where have you worked? What's been your training, your work experience that enables you to give this testimony? Did you graduate from coroner's school yesterday at 5 o'clock, or have you been examining deceased bodies for 15 years? What is your experience practicing in the field of whatever it's going to be? Have you written any books or published any articles that establish your expertise and share it with the world so that people rely on you and your expertise? And have you ever given expert testimony in court before you testified today? Hopefully, all of this information will be in your statement. You can only ask it to the extent it is in your statement. Which leads us to mock trial competition rule 3. Your witnesses are bound by their statement. So they can't make things up that are not in it. They can only testify to the information that is in it. There is a sort of exception to that. And the exception is fair extrapolations may be allowed. So, if an event occurs at midnight, a fair extrapolation is that it's dark. So then you're going to want to look at information in the statement that might indicate to you why somebody would be able to see something in the middle of the lake or the middle of a river at midnight when it's dark. Your statement is not likely to tell you it's dark, but you can reasonably extrapolate that it is. And so you're going to have questions then about what the lighting was. And you're going to be looking for information in the affidavit that talks about what the lighting was. But your witness is bound by what's in their statement. They can't make it up. Question?
Last year, one of the witnesses were asked a question about what type of alcohol beverage they drank that night. What could they say to that? Is that unfair extrapolation?
Yes, because that information's not in your affidavits. Unless they've said, we had a couple of bottles of champagne and it was a really good champagne, or I don't like champagne, so I pulled out the hard stuff that I had in the container I brought from my dad's liquor cabinet. Unless it's in the statement, you're asking the witness to make something up that's beyond the scope of the problem, and that's not a fair extrapolation. If they say, I had 2 or 3 drinks, and it doesn't identify what kind, is it a fair extrapolation that they were under the influence of alcohol? Maybe. Do the drinks say they were alcoholic drinks? And so that gives you some room to play with, where on one side of the case, you're going to want to infer that I had a couple of drinks that night meant alcohol. And on the other side of the case, you may want to argue, I didn't say I was drinking alcohol. I like my root beer. And so it gives you some room to play, but those are the kinds of things you're looking for. Exactly what is said and what is reasonable to assume based on what was said. If they said, I had a couple of drinks, and so I was kind of woozy getting onto the boat because my balance was off, then is it a more reasonable inference that what they were drinking was alcohol? Yes. So you got to look at those facts. Mock trial competition rule 4. If a witness is asked information not contained in the statement, the answer must be consistent with the statement and can't materially alter or affect the substantive issue. So if you're going to try and infer that if they were drinking Jack Daniels as opposed to beer, they were more drunk than they would have been had they had a couple of bottles of beer, and there's no information in your mock trial packet to support that, that's not a reasonable extrapolation from your facts. Okay, exhibits. You have the same issue, and there are a lot of exhibits in this packet this year. I haven't looked at all of them, but I did look enough to know there are a lot of exhibits in this packet this year. Rule 401 still applies to your exhibits. The information in the exhibits, because they're evidence, must be relevant to your case. You've got to be offering it to prove that something that matters is more or less likely to have happened. Prior context of the prom dress. An exhibit about who spent what on their prom dress is not relevant to whether or not after the prom that night there was an accident on the river. So it's not relevant. You got to look at whether or not your exhibits are relevant. I think you can presume that there is intended to be some sort of relevance, or you wouldn't have the exhibits in this packet. But your job is going to be to tie that up and figure out why it's relevant. You've also got to use your exhibits and have them offered by a witness who has knowledge of the exhibit, who's seen it before, who's created it before, who received it in a business capacity and relied on it to make a decision. It's got to be somebody who had some contact with that document that matters to your case. Questions to admit an exhibit. These come out of Mock Trial Competition Rule 42. They're pretty fundamental and pretty basic, and they break this down in a very simple fashion. The purpose of this is to establish the foundation for the court about why this witness can testify about this document. It will seem time-consuming and burdensome to you, but it has the advantage of showing your judges that you know what you're doing in trying to put the exhibits in. So you walk through those exhibits, and you walk through these questions as you put in your exhibit. Pick up the exhibit and you say, Your Honor, may I approach opposing counsel and the witness with what has been marked as proposed exhibit 1, 2, 3, or 4. And you hand it to the witness or to the lawyer, and you have the lawyer look at it. And the judge will then tell you whether or not you can approach the witness stand with the witness or with the exhibit. Let the record reflect that I'm showing opposing counsel what has been marked as proposed exhibit number whatever. You'll approach the witness. I'm handing you what's been marked as proposed exhibit whatever. Do you recognize this document? And the witness has got to say, well, yes, I do. What is this document? And they'll say what the document is. And then you'll ask them, does it appear to be a true and accurate copy of the police report or the expert report or the job application or whatever it is you're trying to put in? And they'll say, well, yes, it is. And then you'll move for the admission of the exhibit. And at that point, once it's admitted, you can talk about the rest of the content of the exhibit. But you've got to lay that foundation to get it in. And you should practice that so that it's really, you'll walk through it really quickly, because you'll be working with your witness, and your witness is going to know what all those answers are before you do it. So it won't need as much time as it seems like, but you kind of need to walk through it. Your thoughts about your direct examination. By the time you get to trial, this is a piece of your trial that you have control over. You as the lawyer are going to work with a witness who's on your team, and you guys are on the same side of the case, so that you can kind of orchestrate this process like a very well choreographed dance, with you asking open-ended questions and your witness volunteering all the information that you want that witness to volunteer. Your questions are designed to guide them through those facts, but let them talk. We talked a little bit about how there's a lot of extraneous information in your affidavits that isn't relevant. But some of it leads you to craft a character with that witness. And you should feel free to do some of that. Remember, when you go to competition, there's going to be 4 rounds in one day of the same case. You are going to have judges there at 4 in the afternoon who were there at 8 o'clock in the morning, and they've now seen this witness 4 times. You want yours to be the one they remember. And so your student team members who are the witnesses need to think about how they're going to portray it. And I use this example every year, but it remains my favorite example. We had a case one year that involved drag racing. And there was a designated witness, and your witnesses are not designated as male or female, and they have gender-neutral names. So you can assign male or female students to those roles. One of the experts was a mechanic who'd been working on the drag racing cars. We get to competition, and one of the teams showed up, and their mechanic was a little itty-bitty tiny girl with curly dark hair and a big bow in her hair. And her character, as she delivered her testimony, was, do you guys know what a valley girl is? I'm dating myself, right? But she was very feminine, and she talked about how the kid driving the car was her BFF, and they'd known each other forever, and she was absolutely freaking adorable. My team hated her because she was so different than how we had envisioned that character. And she was so over the top with that character that we thought, oh, nobody's going to like her. She's going to be off. She got a Best Witness Award that year because she was memorable and she was interesting and she was entertaining. She knew her facts. She knew them cold. She could describe for you what a spark plug did and what it didn't do. She knew her stuff, but she was interesting in how she presented herself. And so the judges remembered her, and she scored very, very well. So think a little bit outside the box as you try and figure out how you're going to portray that character, because you get to do that in a way the judges are going to remember. Okay. Here's the other thing y'all need to remember, and we all forget it. We forget it in real world, and we forget it in mock trial world, and that's to listen to the information you're being given. Even though you will have practiced for 2 or 3 months with your witness before your witness gets on the stand, and you are going to feel a symbiotic relationship with your direct examination witness. You know if you start the question, they're going to know what the answer is before you finish it. And you'll get into competition, and they won't give you the information you think they're supposed to give you. If you are not listening, you will miss that. And so key information that you need in the lawsuit that your teammate will have written into their opening statement or their closing statement as to what we've presented, and you heard all this evidence, may not get in if you don't listen to your witness and make sure when they're as nervous as you are that morning that they remember to give you all of the answer you're expecting. It needs to be a conversation. So you need to listen to the answer, and if they don't give you everything you're expecting, step off your pre-rehearsed script and ask them an additional question so you get all that information. Don't stop listening. We all do it, and it kills us every time. Okay, I think that's it. unless I just hit a wrong button, which is always possible. No, that's it. Questions? Comments from other teachers or coaches? Okay, next.